the prohibition does not allow you to evict the tenant because of non-payment of rent. Now it prohibits you from increase your rent. Now, AB 1482 places a statewide rent limitation in California. California has become the second state in the United States after the state of Oregon to impose a statewide rent limitation, meaning California is under statewide rent control now, with certain exemptions. Okay, so this particular prohibition right now, or moratorium right now, covers rent increases. There's no rent increases. This is for unincorporated area in Los Angeles County. Okay, cover mobile home parks also. Third, it also prohibits pass-throughs and late fees, interest, and late charges. What are pass-throughs? Pass-throughs, landlord's responsibility, like certain type of charges, utility, property in the commercial properties. There's some triple net charges like insurance. Those are generally paid by tenant, but in a commercial property, the triple net leases, those are the tenant's responsibility. Those are pass-through charges. So any pass-through charges, including late fees, interest charges, or whatever charges, they are all prohibited. Okay. If a tenants are late in making their payments, okay, you cannot leverage a late fee on it, even though that late fee is prescribed in your lease agreement. Okay, does this mean tenant don't need to pay rent? Okay, right now this is a rent deferment. Basically, if you are not, if the tenants are not allowed to be evicted, they don't have to pay rent. Doesn't mean that their rent are forgiven. Okay, they don't have to pay rent now. But let me correct myself. Not that they don't have to pay rent. They do have to pay rent. But if they don't pay rent, you just can't do anything about it now. Okay. Now there are different people, lawyers, California Association of Realtors, AOA, the Apartment Association, different associations have different things about paperwork. Oh, should I have the tenants sign a lease modification agreement? Okay, I'm willing to reduce their rent by whatever percent, give you a 10% discount during this COVID-19, or 20%, 25% discount. Okay, you sign this agreement, you agree that after the COVID-19 over, that you will pay the rent. In this agreement, that it depends which form that you use. That you have 6 months to pay, you have 12 months to pay, you work out, or you can work out a particular payment with the tenant. Personally, I don't like any of those. Okay? I do property management. I write my contract, my lease agreement myself. Once the lease agreement is executed, the tenant and landlord have a binding contract. If the tenant defaults by not paying rent, even under COVID-19, their rental obligations does not get waived. So why should I execute a separate addendum or a separate document or separate agreement with the tenant to reduce their original contractual obligation? Is that not to the disadvantage of the landlords? If the landlord has an original contract that binds the tenant to the original rent, reducing the rent in a subsequent agreement is only gonna be to the benefit to the tenant, but to the detriment of the landlord. Is it not? So it's up to the individual landlord if they want to use a particular CAL form or private agreement, or the agreement they find online, or to use the AOA agreement in terms of a modification of terms or reduction of rent, or a particular payment plan. if my view is this, if a tenant signs a contractual agreement, if the tenant's not going to uphold that original contractual agreement, what makes you think the tenant's going to uphold the subsequent reduction of rent contractual agreement that you're going to sign with the tenant? Make sense? It's up
Tony,
to
we
you.
have a question.
Yes.
Do you know when the prohibited pass-through late fees and triple net fees will end?
Well,
Do you have any information?
right now, the prohibition is until May 31st. The moratorium is until May 31st. So after May 31st, you're supposed to be able to evict the tenant. Okay. Now, the court's going to be open on June 1st. I don't know. If the court is going to be open, there's going to be a huge backlog of cases. Not just a UD100, not just unlawful detainer and landlord-tenant related dispute lawsuits, but all the other civil cases that people that have not been able to file, or the plaintiff and attorney have not been able to file, including myself. I have a claim I was going to institute against a particular defendant that I cannot file at this point. So I have to wait until the court reopens. So I would advise that a particular landlord do not go file this unlawful detainer yourself, especially when you are inexperienced in doing this. Hire a eviction law firm, not just any law firm, or not hire a general real estate attorney. At your brokerages, you have your own company attorneys. Those are real estate attorney. I mean, not because they are not knowledgeable. They are very knowledgeable. The reason I don't recommend that, because they are expensive. Okay, use law firms are particularly in the business of doing tenants eviction only. Okay, and let me give you several of these. Let me see. Well, you guys can email me. You guys have been requesting me for those information before. I regularly get people email me for that. Just email me. I'll send you 3 of the very popular local eviction law firm. That includes Dennis Walk and Ellinger. And close the windows. Plane flying overhead. For regular residential eviction, the cost for an uncontested case is about $650 to $750. Uncontested case meaning the tenant is not going to file an answer and challenge their landlord's claim. Okay, so let's continue. Laura, did I answer the question? Laura?
Yeah, you did. Thank
Okay.
you.
What responsibility do tenants and landlord have as it pertains to the moratorium? Okay, tenants are encouraged to deliver notice to landlord in writing. Okay, we'll cover that a little bit later. Okay, at least try to talk to a tenant about paying partial rent. Now, here's the catch. Okay, landlord must accept tenants' self-certification as valid form of notice. What does that exactly mean? That means the tenant can just tell you, I am affected by COVID-19, and you have to believe me. And you have to take what I said and accept that as true. That's what it means. Okay, landlord must accept tenant's self-certification. There's no third-party certification, okay, required right now. Now, I have one of my own tenants that was not paying rent in April, and she says she's affected by COVID-19. She claimed that she works for Cheesecake Factory, and then I told him, according to governor's executive order, the tenant must. Let me read the next question here. Then we'll come back. Okay. When should the tenant notify landlord that the tenant is unable to pay rent? Tenant must notify landlord through self-certification within 7 days after rent is due. Okay. Now the governor's executive order, it says 7 days before rent is due or within 7 days after the rent is due. Okay. Now, then it's go on and say, unless extenuating circumstances exist. What does that mean? Really nebulous, really undefined. Okay. Basically, here it says that the tenant, if you don't pay rent due to COVID-19, okay, you must let the landlord know in writing within 7 days if when the rent is due. If the rent is due on the 1st, well, you need to give the notice by the 7th of each month. So this particular tenant gave me a verbal notice, okay, called me and told me that I cannot pay rent because I lost my job. Or actually, she says she had a reduction in hours. So I say, I need proof. She sent me a letter with a letterhead from Cheesecake Factory, a blank letter to all the employees of Cheesecake Factory due to COVID-19. The restaurants are closed. Employees either are laid off or has a reduction of rent because of takeout only. So I told the tenant, you need to send me a letter from your employer, your supervisor, stating that yourself, with your name on the letter, is personally affected by COVID-19. Now, because of that demand, the tenant subsequently had paid the April rent. So I would encourage the landlord, citing the governor's executive order rather than the local county's order, saying that the tenants, the landlord must accept tenant certification. Okay, I'll take that the governor's executive order is also law also. So I will quote that part instead of this part right here. Some tenants, they are able to pay rent, but they know everybody else is not paying rent. So they, even though they are able to, they might not pay rent. Okay, so who do these protections apply to? Again, all residential and commercial tenants, okay, including mobile home occupants. That's why city have its own eviction moratorium. Okay, check rent.lacounty.gov. Okay, what if my landlord still try to evict me? Okay, landlord are not, tenants are not required to move until a sheriff have served a notice to vacate. Okay, which will not occur until the governor's executive order have been lifted. Okay, most of you probably know already, the eviction process is such that you serve them a complaint. That means you serve them a court paper, the lawsuit, UD100, unlawful detainer, which is a lawsuit to evict a tenant. The main purpose of UD100 or the unlawful detainer is to regain possession, not so much for money, even though you can ask for restitution. Okay, but basically eviction is to recover possession and not go after money. Most of the time when you evict a tenant, they're deadbeat, you're not able to collect delinquent rent anyway. So, okay. But at this point, landlord cannot evict, okay? Even if in a normal process of UD100, even if the tenant doesn't challenge a landlord wins, or tenant doesn't file an answer, landlord obtain a default judgment, and you get a writ of judgment, then you have a sheriff go out there and post a notice for 5 days. After 5 days, and if the tenant still doesn't vacate, contact the sheriff, then the sheriff will contact you in a designated time. You will go there, the sheriff will meet you. If the tenant is uncooperative, he doesn't want to move, the sheriff will physically remove the tenant from the property. But now, even if you got a court judgment now, okay, you get a writ of judgment, the sheriff is not going to go out there and evict the tenant, okay? So not only the court is not going to allow you to do that, the sheriff is not going to do that, and you're not able to file any of these evictions right now. On top of that, the Judicial Council came down with an emergency ruling last month on April 6th. Now postpone any set hearings, I mean the eviction court cases hearings, okay, for at least 60 days, and prevents courts from accepting any eviction cases until 90 days after the state of emergency is lifted. Let's say the state of emergency is lifted on May 31st. You cannot file eviction until 90 days after that, okay? It says prevents the courts from accepting any eviction cases until 90 days after the state of emergency have been lifted. Okay. Under this Judicial Council emergency rule, there's a bunch of rules, but I'm going to only mention the ones that is applicable to you guys in terms of landlord, tenant, and property management. There are a bunch of other rules regarding any civil cases and domestic violence, which I'm not going to cover. Okay, emergency rule number 1, which is the most important one, is regarding unlawful detainer. Again, unlawful detainer is to evict a tenant, recover possession. Okay, this particular emergency rule number 1 covers application. That means it applies to all actions. Action meaning lawsuits for unlawful detainer. Okay, applies to all action meaning all lawsuits relating to unlawful detainer. Okay, also. This particular emergency rule number 1 regarding issuance of summons. A court may not issue a summons on a complaint for unlawful detainer. What is a summons? When you go file for an eviction, meaning you go file a lawsuit, okay, the tenant must know they are being sued. So there's a court summons. That means you need to give notice to the tenant that they're being sued. The process is called a summons. Okay. The court may not issue a summons on a complaint meaning a lawsuit, okay, for unlawful detainer, unless it is for public health and safety protection, okay? So subsections C, entry of default. What does that mean? A court may not enter default judgments, okay? Or for default judgment for restitution, meaning recovery of money, okay, in an unlawful detainer action. Even if landlord, you're right, you have all the evidence, you have actually filed the eviction cases already because it's before the court was closed, before this moratorium, you're already in the process of evicting tenant, you file all that. But now this Judicial Council emergency rule, emergency ruling came down that say the court may not enter a default or a default judgment for restitution. That means this rule prohibits the court from ruling in your favor. Okay, so 4th, the time for trial.
Tony,
Yes.
I have a point of clarification. Is this for LA County or the whole state of California?
LA County. Judicial Council, I think this is LA County.
Okay, thank you.
Yeah. So time for trial. Okay. If a defendant has appeared in an action, that means in a lawsuit, the court may set a trial date earlier than 60 days after the request of trial is made. So basically, everything is deferred at least 60 days or 90 days. Okay. Now, there's a sunset rule. Until 90 days. Yeah, so it's basically all this is saying there's nothing you can do right now, okay, until 90 days after the emergency have been lifted. So anywhere from 60 to 90 days. Now, different jurisdiction, if you're in Orange County, might be different. If you're San Bernardino County, might be different. Your Riverside County might be different. Different city might have more stringent restrictions, like AB 1482, the statewide Tenants Protection Act of 2019. It applies statewide in California, but it has some exemptions. What are those exemptions? One of those exemptions is for jurisdictions that already have a more stringent tenant protection in place already. So if those jurisdictions or cities or counties have more stringent protections, AB 1482 does not apply. Same thing for the Judicial Council here. If certain particular jurisdictions have more stringent protection, those more stringent protections will supersede this ruling. Okay, next. Now we talk about these are the renters. How about for property owner, landlords? Okay, what relief is available for property owners impacted by COVID-19? Okay, the large of landlords, their property is not free and clear. They have loans on it, and these loans, if they're owned by government or national or state chartered bank or private institution, you may be eligible okay, to either reduce the payment or delay the payment for up to 12 months. Now I was thinking, yeah, I got a little bit reserved. I'm able to make my payments. Maybe I should just pay rent. I'm not rent. Pay the mortgage payment. So I got several mortgage payments that I need to pay. So my wife told me, go apply. Don't make any payments at all. Conserve your cash. And I thought about, let's see. If I call them, probably no one gonna answer the phone. Indeed, I tried to call my mortgage lender. Nobody answers the phone. But I went to their website. To my pleasant surprise, in minutes, I was able to apply for forbearance. It says only 3 to 6 months on the website. It doesn't tell you for sure either 3 or 6 months. It says you will get an email confirmation. And then I got an email confirmation subsequently. I got a 6 months loan forbearance. And I went on and went to the website of another property that I have a loan on it. Again, the online process is quite easy. Then I got another 6 months forbearance on that property. Then I own another property with another person, and then I asked the other owner, "Hey, let's go get a forbearance on that property." And he was able to get a 6 months forbearance on that property as well. Now we have another larger property, but it's a commercial loan because it's a multifamily, but it's a larger unit. So the commercial lender is giving us a tough time right now. And they want this, they want your P&L, they want your financial document, rent roll, detailed tenants information, lease copies, and a bunch of other stuff. They are throwing roadblocks to us right now. So up to this day, I'm not able to get a forbearance. If any loan forbearance that I want to get is that one, because that is a larger 16-unit apartment loan on it. So landlords, even though if you don't need the forbearance, contact your lender by website. Don't bother calling them. It's unlikely they're going to answer your phone calls. So I would think that it's very likely you are able to get at least 3 to 6 months of forbearance. Now, as to the repayment, this loan forbearance is a loan deferment, not a loan forgiveness. Okay. Now, is the deferred amount or deferred number of payment need to be repaid at the end of that forbearance period? Or if that number of payments is going to be extended and add to the end of the long term? That is not clear. Okay. Probably have to be after this COVID-19 thing that individually you need to talk to the individual lender. But at this moment, none of the lenders that got back to me or have clear indication on their website as to the deferment, if it's going to be payback at the end of COVID-19, or is those number of months payments missed going to be added as additional loan payment terms toward the end of the amortization period. Okay, let's continue. Will they be able to charge a late fee? Yeah, patently no. Right now, you cannot charge a late fee. Okay, late fee may be waived at this. I was referring to the tenant part, but the lender, okay, lender may waive the late fee. They may not. Okay, but they're supposed to. And if you don't make any payments right now, they cannot consider you as default. It should also the instructions to a lender is that not report the non-payment of rent as a delinquency. So technically, it's not supposed to hurt your credit. Okay. Next question. Okay, will my credit be impacted for not making payments? Okay, depending on the assistance provided by your lender, negative reporting to the bureau may be suspended. Okay, suspended doesn't mean that they are not going to report. They're just not going to report now. Okay, What happened at the conclusion of forbearance period? Okay, here we go again. Okay, lender may offer a repayment plan or agree to modify your long term. Okay, repayment plan meaning you have to make up the payment after the forbearance period. Okay, modifying the long term meaning possibly those missed number of payments could be added to the end of the long term as additional payment. Okay. Now, what is considered a COVID-19 hardship? A reduction or total loss of income, okay, due to reduced hours, layoff, substantial decrease in business income. Rental activities is a business. So for a tenant on payment of rent, the landlord suffers a reduction or loss of income. So that will qualify for COVID-19 hardship. Even if you didn't lose any rental income, but because you have substantial expenses due to medical expenses related to COVID-19, or if you care for somebody that is diagnosed or tested positive or under treatment for COVID-19, okay? Okay, next, my property is currently in foreclosure. Let's skip that. Foreclosure 60 days suspension. I'm a landlord and my tenant's inability to pay has created financial hardship for me. Can you help me? Okay, now this is for unincorporated area in LA County. Okay, contact this number right here or email rent at Department of Consumer and Business Affairs at .lacounty.gov. Is mortgage relief available to businesses? Okay. Currently, there's only residential mortgages. Commercial, I haven't heard much about commercial loan being on the forbearance program yet. I have a client owns a freestanding building in Moreno Valley, commercial, 11,800 some square foot. I just leased that last year for 24,700 a month. The tenant did not pay rent in April. The same landlord has another commercial property. The rent is 35,000. That tenant did not pay. So this particular one landlord, because of two commercial properties, he did not get $60,000 in rent in April. Okay, I'm not sure if the tenant's gonna pay rent in May. They haven't paid so far. Now, both of these properties, the one in Moreno Valley is a vocational school. The other one, $35,000 a month rent, is a child care type of school also. So all schools are shut down right now. If the business operator is not able to operate the business, generate no income, it's unlikely they're going to pay rent. But right now, there's not much assistance for commercial properties owners. Okay. Now, my mortgage lender servicer is being unresponsive and or non-compliance. What can you do? Well, talk to California Department of Business Oversight. Okay. Here, the information right here. Can a third party individual organization assist me with my mortgage or foreclosure? Of course, if somebody willing to pay your rent, pay your mortgage payment, yes. Special events, okay, that's not related. Okay. This one thing. I just heard this on the radio yesterday. This came out earlier last week. LA represents. What is that? Mayor Garcetti and the city council, LA City Council and the city attorney. Now they have assembled, they put together a coalition of law firms and lawyers. Okay, what is that for? They are asking them to do pro bono work. Ask these law firm and lawyers to do free work, provide free services to tenants. Okay, so basically, they want the delinquent tenants or tenants affected by COVID-19 have legal representation, so they would able to either sue the landlord or in a much stronger position in negotiating with the landlord in either rent reduction or lease modifications. Okay. Landlord usually have upper hand in most of the eviction cases, 90% of the cases. If there's any attorney at all, 90% of the cases, the attorneys are on the landlord side representing the landlord, but not the tenant. But now there's something called LA Represents. Okay? LA Represents is a brand new program that the city get together a bunch of law firms and lawyers to contribute their time to assist tenant in litigation or suing the landlord or working with the landlord, working with the tenant to have the landlord perhaps forgive the rent, reduce the rent, modify the lease agreement, and so this is actually not a good thing for landlords. Now these are all the law firms. Okay, right now the LA County or LA City has gotten so far, and even have a site say, I need a lawyer, okay, to help me. They can go to the LA County's website, the LA City's website, and find these lawyers' information. And have a section say, if I'm a lawyer who wants to help, okay, if your lawyer or law firm want to participate and tender free pro bono legal aids, okay, they can go to that county website and contact the city website and contact the city and volunteer their service. Okay, continue. Most of you guys are probably very familiar with the Executive Order M3720 already. This is the California governor's wait a few more minutes. Executive order that was affecting only residential tenants only, like we have seen earlier. Subsequent to that March 27 executive order, commercial properties, certain areas, also under the eviction moratorium already. Okay, qualification required for tenants to fall under the protection of this governor's executive order issued on March 27. It's like the tenants must have been current with their rent prior to the executive order. Meaning if the tenant was delinquent, owed you rent, the executive order didn't apply. That was back in March 27. But subsequent to March 27, we have seen a bunch of these executive orders from different cities, different counties, having the same effect of prohibiting evictions, regardless if the tenant has been current or not. Okay. Then in this executive order, tenants must notify landlord in writing before rent is due or within 7 days afterward. Okay, that they are unable to pay a portion or all of their rent due to the reason related to COVID-19. And the tenant must retain verifiable documentation supporting their assertion of the inability to pay. Now, this is the governor's executive order back in late March. But since then, LA County and other places said that the landlord must accept tenants' self-certification as sufficient. Okay, that basically defeats the governor's executive order about the verifiable documentation. So the bottom line, tenant does not need to give you any proof. You don't need any letter from a supervisor, a company where they employ that says that they have been laid off, their hours have been reduced, their incomes have been reduced. None of that proof is needed now or required now. So if your tenant just say that, well, I cannot pay rent because of COVID-19, basically that is it. So what can you do? Like Dennis Block, but Dennis Block is a very well-known attorney in the eviction business for over 40 years. They say, there's nothing you can do right now. He's not even issuing 3-day notice to pay rent or quit. I'm not either. I didn't issue a single 3-day notice to pay rent or quit in April or in May. Why? The 3 days notice to pay rent or quit is an instrument to stop the clock for eviction. Now we have a blanket eviction moratorium. What is the use of giving a 3-day notice to pay rent or quit when the clock cannot stop? And also, providing the 3-day notice to pay rent or quit is kind of like a threat to a tenant. If you issue a threat to the tenant and you cannot back that up, would that be a good thing? To me, absolutely not. You'll become like a teethless tiger. So, so if the tenant's not paying rent right now, I just call them or text them and say, hey, do whatever you can. If you can, make a partial payment. I'll try to work with you. I understand that COVID-19 affects you and hope your family is safe and hope you guys continue to stay well and safe. And just be polite, be cordial, be cooperative, and try to be on their side and understand their situation. That's about all you can do. Okay, next. There are some call forms. As I alluded earlier, there are a couple of them at least. The NTAP, the Notice to Tenant of Ability to Pay Rent During COVID-19 Pandemic. And the RPD, the Coronavirus Rent Payment Delay and Repayment Agreement. Now, you probably know my feelings about that already, as I have mentioned. This is a new form, Coronavirus Repayment. The RPD, this is a new one started in April 20th. Now, again, why do I want to execute this new agreement or form or addendum, modifying my initial lease agreement? This is only going to trump my original lease agreement, deprive myself, the landlord, with my original right, and waive the tenant's original obligation. So I'm not an attorney, so I cannot give you any legal advices. But for me, as a property manager, as a property owner, I do not give out any of these notices to my own tenants or to any of my management tenants, or advise the landlords. A number of landlords have contacted me about maybe having a tenant sign a new form, and I advise against my property management client not to execute any of such form. Then after I explain to them about the contractual obligations, they all understand and they agree and not want to give the tenant additional right under the new contractual agreement. So it's up to you if you want to use any of these forms. Okay. News and update. 2 more minutes. A whole lot of stuff in property management that I'd like to cover, but let's see. Okay, we talked about earlier, tenants are 6 months to repay, okay, but that had been extended in some local jurisdiction. There's a rent freeze. The non-payment of rent must be due to several things. It's a presumed or confirmed diagnosis of COVID-19, your layoff, loss of hours, loss of income, income reduction. The situation is due to a state of emergency and all that. Okay, now here, how does the temporary moratorium works? Okay, tenant now have 12 months, okay, following the end of the moratorium to pay back the amount of rent, not 12 months from the time that they missed their payment. Okay, if they miss February or they miss March or they miss April, okay, it's not 12 months from April, not 12 months from March, not 12 months from February. It's 12 months starting at the end of the moratorium. If the moratorium ends on May 31st, starting June 1st, it's the first month. Okay, you have 12 months to pay. Now, another issue, that 12 months to pay, let's say the tenant missed 2 months rent or 3 months rent, February, March, April, or March, April, May, okay, or whatever month they missed. They have 12 months to pay back. How? If they miss 3 months rent, do they divide the sum of the 3 months by 12 and they make it up 1/12 in each of the 12 months? Or do they get to pay at the end of the 12 months period? It doesn't say. The law does not require a tenant to make all those rent payment in a particular proportion or fashion. So at this moment, the law only says they have 12 months following the end of the moratorium to pay back any rent due. Okay, now there's a template that the tenant can use. The tenant savvy enough, they probably go to the county's website, then get one of these forms and send it to the landlord. But so far, I haven't received any of these forms from the tenant. And most tenants didn't even send me notice, provide any proof, except one tenant that I told you guys earlier about, that cheesecake factory tenant sent me a blank blanket state company-wide letter only, not specific to a situation. So how long will the temporary moratorium last? Until May 31st, unless extended. So we'll see. These are the cities have residential and commercial. Some places are commercial, some places are residential only. So if you don't know, if you're in an unincorporated area or LA County, just go to the county's website. Okay. Okay, this is a notice I showed you guys earlier. The tenant can submit. Okay, these are the information, LA County information. Okay, and actually there are a lot more. I want to give you some updates on the latest landlord tenant stuff. Okay, I'm going to just run over a few minutes for those who are interested. I think that's important for landlords. Now, Section 8. Previously, a landlord can say you just merely you don't want to consider Section 8 tenants. Effective January 1st, 2020. Okay. Let's see. Okay, under two state assembly bill. Okay. The landlord cannot summarily deny a Section 8 tenant. Okay, now, but understand this correctly. Okay, it says you cannot reject a Section 8 applicant in their application. It doesn't mean that you must accept a Section 8 tenant. Okay, you just cannot summarily say, hey, we don't entertain Section 8 applications. Okay. You must entertain Section 8 tenants, applicants, okay? But you doesn't necessarily have to accept them. They still need to qualify. How to get around that? Let's say I'm the landlord and I don't want any Section 8 tenants in my property. Why? Because Section 8 tenants require an annual inspection and all this, especially if the unit is vacant. And if it's a Section 8 tenants applying, they're going to send out inspector come out here and inspect your property. You can take time for appointment, all that. I have inspectors that don't show up. Okay, that will delay the inspection. All this time, the property is vacant. I'm losing rent. Okay, so I just told whoever that applies that we don't accept Section 8. Now you may not. They ask you, do you accept Section 8? You say, sure, we do. You're welcome to submit your application. There's a $35 application fee per adult over 18 years old. And also, you need to submit all your financial documents in addition to whatever Section 8 paperwork. And in addition, we run both credit check and background check. And tenant need to be eligible because we only have 1 unit for rent. So we cannot just say we just rent it to you, Section 8 applicant. The other applicant could be more eligible. Okay, so I would use the financial eligibility and the credit worthiness as the final determination. But just be careful, do not deny an Section 8 application. Okay, so you do accept the application. You can reject them on the basis of credit worthiness, okay, but not because of the status of accepting public assistance. Okay, I hope that's clear. Now, you cannot discriminate against a tenant because of source of income. Okay, if they make no money or they hardly have any income, but they receiving enough public assistance, okay, to pay rent, you cannot deny the tenant on the basis of the source of the income. However, you can deny the tenant because of credit worthiness. If the tenant only have a credit score of 509, yeah, I don't want you to be my tenant. And it's legitimate to deny a tenant with a derogatory credit or with prior evictions. Okay. Legal update. Okay, a few more.
Tony,
Okay, yes.
somebody was asking when you were going over that website again for, I think it was LA County.
Uh-huh.
Could you post the what it was again for the COVID-19 ERA?
The COVID-19 ERA. Right here. Okay, the COVID-19 ERA is the emergency program, the emergency rent assistance program. Okay, 211la.org/COVID-rental-help.
Okay.
Okay. Now again, apply this immediately. $3.7 million. Are you kidding? That could be gone in just minutes, if not seconds. Oh, another thing I want to mention. That's my assistant been telling me. She called me a couple of times regarding EDD. I have not received the $1,200 stimulus payment. Now, one of my clients, the client that I told you about, that owns 2 commercial properties that they're missing $60,000 of rent. And that guy, Mr. Jung, told me he has already received $1,200 stimulus payment. And I say, I still haven't received mine. And then that's the PPP program that is available. But then real estate agents, realtors, are considered independent contractors. There was a difficulties in applying for unemployment payments. However, recently I have received this email says the realtors qualified to apply for unemployment or EDD assistance. So I say, well, let me just apply and submit and see what happens. And then apply and submit. And so my assistant did that also. And she called me and said, "Hey, Tony, did you receive anything from an EDD?" I say, "No. The website says my eligible benefit is 0, so it's hers." Unbeknown to me. In between time, including a few days ago, I received a bunch of letters from EDD, and I put each of them all the same letters except a different period from from February 11 to 19 or whatever. Have you been this and that? And so I answered those questions, signed it, and put it in my mailbox day before yesterday. Yesterday, when I checked my mailbox, there's a letter from EDD. Inside have a Bank of America debit card. So I say, really? Is this a blank debit card that they're gonna credit me money? Or is that money in there already? Of course, that requires activation. I go online, try to activate. I wasn't able to activate. I call my phone. The automated system, I was able to activate the card. And it says it's a $4,404. Now, I don't know if that's true or not, but it asked me to set up a PIN. So later on, I'm going to go out there and see if there's any money in there. So realtors, there's a program out there that is available for realtors, independent contractors to apply for such a benefits. So I don't know, Laura, do you hear anything about that?
I have heard that you can apply as a realtor, you can apply for the benefit, but I haven't heard about the debit card.
Yeah, so if you guys...
I haven't gotten my $1,200 either.
You haven't? Yeah. Yeah, I don't know this $2.2 trillion that the stimulus program is really a good program or not. I mean, lots of people needed help, and I think the government resources really need to go to the people that are really affected, and not really go to people that perhaps maybe don't need the money as much. In a way, I'm glad that I received the money, but also in a way that I really feel kind of undeserving. There are a lot more people that really need the money a lot more than we do. But the program is out there, EDD, Unemployment Department. So go Google it. If you have not applied, apply. Maybe you'll get the debit card in the mail also. So any other questions? It's after 12 o'clock already. I don't want to always overrun, but there's just so much stuff, especially in the landlord tenant arena, and all these are important. These are rent notice. Another one, let me just brief cover that maybe in the next 60 seconds. Okay, AB 1110, rent notices. Okay, before you need to give a tenant 60-day notice if you increase your rent by more than 10%. Now it's 90 days. Okay, then you say AB 1482 prohibits rent increases for no more than 5% plus CPI, cost of living increases adjustment together no more than 10%. But what is the use of giving 90-day notice if you don't increase, you can increase by 10%? Well, but AB 1482 do it exemptions. Single family home duplex and property newer than 15 years of certificate of occupancy issuance. Okay, those are exempt. Those, if you want to raise more than 10% rent, you can, you may. However, instead of giving a 60-day advance written notice, now you need to give it 90 days. Okay. Of course, a lot of people know already AB 2343 on all these notices. Okay, before Saturday, Sunday judicial holidays count. It's kind of complicated counting system, but now just all judicial holidays, Saturday and Sunday don't count. So you have a 3-day notice. You give on Wednesday, Thursday's first day, Friday second day, Monday's not the third day, not Saturday and Sunday. Okay. If you give the notice on Saturday, Monday will be the first day. Okay. Yeah, there are lots of. I can't cover everything. There's just so much volume. I'm looking forward to reopening. So in my live class, it's a 2-hour instead of 1 hour. A 2-hour live class at the Tri-County Association of Realtors in Walnut. So if you guys are not TriCo members, go to Tri-County's website and look at the calendar. I have a 2-hour class of landlord, tenant, and property management. I offer a 2-hour class. Also, these are free classes on advanced contract and useful contractual clauses. I have a class on opportunity zone. I have a class on listing and selling business opportunities. All these classes are free. There are 3 other classes that are full-day class training from 9 to 4. These 3 classes are 1031 tax deferred exchanges from 9 to 4. A commercial property class also from 9 to 4 covers the listing and selling and leasing of commercial properties. There's a lot of money to be made in commercial leasing also. There's another full-day training class from 9 to 4 for investment property analysis. So the investment property analysis and the 1031 is a perfect combo. So if you do commercial properties, these 3 classes is really invaluable. I have one more class this month that is on commercial properties. Let me see what day is that. I'll give you that right now. Okay, Registrar of Tri-County. This is today's class. Oh, on May 18. On May 18 from 11 to 12, there's commercial properties. I will cover 1 hour. I mean, I don't know how much I can cover, but I'll cover as much as I can of at least the fundamental of commercial properties. Okay, these are my live class schedules. Go to Tri-County website and they have all the information. Okay, everybody. Oh, here we go. Here's our new puppy. We are just sheltering in place, staying at home. So every day, and we're taking Rocky out to play hide and seek. We're actually enjoying our time. We're having a wonderful time right now. So everybody, wish you guys well. Continue to be safe and continue to be healthy. And I look forward to talking with you guys and seeing you guys. Any other questions?
No, we're good.
Okay, I see a bunch of chat messages here. Thank you. Okay. I'll just thank you messages. So you guys are welcome. All of you guys are welcome. Yeah, you guys give me a call sometime. We just at home don't get to go out much except taking Rocky out. So I really miss
Give
it.
your contact information again, Tony.
Oh, my contact information. Okay.
Yeah.
Let me just type it up here. Okay, now you guys have questions. Best thing is to call me. I'm very good with communication. I always return my calls and I always reply my emails and text messages. Even though sometimes it might take me some time, especially emails. 4,000 some emails. A lot of them I haven't even read. But if it's in my box, I will get to you. Please, if you don't hear back from me, do come back at me. Shoot me another email or text me or call me. Best thing is to call me. I can answer questions a lot faster and in full. I'm a terrible text person, not because I don't text back, just because I can't text as quickly as these teenagers. I mean, their fingers are flying on the keyboard and I text a lot slower. So for me to answer your questions in full, a lot of times I want to give you as full as complete and maybe additional information. So if you have a question, call me. I work late. Usually I'm writing my 1031 text exchange book right now. Usually I'm up to at least 1 o'clock, maybe 1:30, working on my book. So you guys are welcome to call me until 10, maybe even 11 at night. It's no problem.
Give them your email too.
Email. Okay. Baker. It's just my name, Tony Lam at gmail.com. Okay, now, I see a good number of people. Karen, yeah, Victor, and you guys. I mean, at least George, Maria, Sylvia. I mean, you guys. Next time, put a camera up so I can see you guys, okay? Call me sometime, chat with me, okay? Nancy?
Yeah, hi Tony. I want to tell you that you mentioned earlier regarding the card you received from EDD. That is true.
You received one too?
No, one of my coworker received it, and then they go to the bank. Yeah, it is money in there.
Yeah, I don't know why they give me like $4,400. I mean, I was utterly surprised, but I mean, I'm not complaining. I'm really glad. But
yeah,
real estate agents, realtors, you guys. I mean, go apply. I mean, if I can get it, I'm sure you guys can get it too. And there's no reason why I should get it, and no reason why you shouldn't get it.
I did apply, but I didn't get it yet.
you applied, but you didn't get it.
Yeah, I didn't get it yet. I don't know.
It might be just processing. I mean, the $1,200 check, they say they're supposed to go to everybody. Now, another thing I'm a little concerned is like,
no, I received the 1,200, but the one with the unemployment is still in process for independent contractor.
Yeah, for independent contractors. So this is a fairly new thing. Independent contractors previously are not have at least have some problems in qualifying for EDD payments. So now I received this Bank America debit card, so we'll see. We go get an In-N-Out burger today with that card or something. So, yeah. So, hey, rest of you guys have a very blessed day, and I hope everybody gonna continue to stay safe. And I know that business could be challenging right now, but have faith, hang in there, learn as much as you can. Don't waste your time just watching TV at home. At this time when you're sheltering in place, equip yourself, position yourself when the market opens again. You're able to capitalize on opportunities. Learn investment properties, learn commercial properties. If you guys have attended my classes before, you know I've explained to you guys, when you go door knocking, asking a homeowners if you want to sell or move, see, some of the people might tell you the next time I'm going to move is to Rose Hill. Okay, so a person can only have one primary home. So if your business is predicated on selling or helping a buyer to purchase family primary residence only, you're shortchanging yourself. Okay, and I'll give you an example. Just because this COVID-19 fiasco happened, one of my agents in my office, Roseanne, came to me, asked me for help. Her client had a commercial property in Temecula. The tenant is a restaurant. Tenant offered $1.8 million to purchase the property. The owner didn't know if that was a fair value. She contacted Roseanne, the agent. Roseanne is not in the commercial space or investment space as much, so she come and asked me for help. So I teamed up with her, look at the numbers, met with the client, and then my valuation is that the property is worth $2.75 million instead. And then I got the tenant to agree in listing the property, and I listed at 6%, at $2.75 million. And a buyer came to me directly, and I represent a buyer, and I closed the property at $2.8 million.
Wow.
Now, if you don't know how to do the analysis, how to do the income valuation, and
Call you.
yeah, given now what is luck? I always say luck is when preparation meets opportunity. That was a perfect opportunity. Now, on the listing side, that 3% commission, I split with Roseanne half and half, but I represented the buyer on my own. So I'm entitled to that 3% commission. But nonetheless, I told Roseanne, I'm going to split half of that with you. So she got an additional $30-some thousand commission from the selling side. So to me, but for her coming to me for help, I wouldn't have that opportunity. And that commission check alone, it's like almost $70,000. Now, there's hardly any paperwork. The commercial side, the paperwork, a lot less than residential side. We have all these lead paint disclosure, blah, 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 blah. And there's hardly anything. And the client was so nice, so easy to work with. Usually commercial loan is 60 days, but we negotiated at 45 days. I asked him, hey, Mike, are you able to close in 45 days? And he was very confident. At the end, he couldn't. So you're asking for another week. He put in $100,000 EMD. He was willing to put in additional $100,000 in deposit, and I negotiated to have him release both $200,000 to the seller ahead of time. So indeed, $200,000 earnest money deposit was released out of escrow prior to closing. And when that was released, we pretty much guarantee that the deal is going to close. So learn how to do commercial property, learn how to do leasing, commercial leasing. Like I told you, the property in Moreno Valley, the lease was $24,700 a month. That's more than $250,000 a year in a lease. Is that not same as selling a condo in Ontario for $250,000 commission? Now, if this is a multi-year lease, a 5-year lease, it could be $1 million, $1.5 million lease. You're entitled to the commission. Is that any different than selling a $1.5 million home than getting commission on a 5-year commercial lease worth $1.5 million or more? So investment property, do learn how to do 1031 exchanges. Why? 1031 exchanges almost guarantee you have two sides. The client have to sell and he has to buy. If you're representing the client selling as a listing agent, who do you think the client is going to use to find the replacement property? It's going to be you. And also, if the client sell a relinquished property for $500,000, in order to defer 100% of the cap gain, he has to buy equal or more. That means you have commission for at least another $500,000 property. But if that client leverage, let's say he has an all free and clear property worth $500,000, he put 50% down, and he could acquire $1 million asset. Together is $1.5 million. Is it not like selling that 500,000 property 3 times? So think about it. So if you haven't ventured much into the investment space or targeting people with 1031 exchanges, well, using this time, learn as much as you can. Okay. And well, I mean, you guys a lot of you guys are still here. It's 12:30 already. Okay, you guys go and have lunch. Enjoy the rest of your day. It's beautiful out there, and life is good, and life is fun. As long as we are healthy and we are well, we are blessed. Thank you, everybody, and I appreciate you attending the webinar.
Thank you very much, Tony.
Especially,
And
Laura.
Thank you.
okay, guys, I'm gonna go. I got things to do. Okay,
Bye,
take care,
Tony.
everybody.
Thank you.
All right, I'm not gonna able to reply all your chat messages. You guys can just text me or call me. Okay, take care.
Okay.
Bye now.
Bye.
bye.